You like to begin your opinions by going straight to the issue. What is the issue before the court? Why are issues so important to you?
Well, I wasn't aware that that's what I did. I'm interested that that's how you look at my cases. In part, I think it's a discipline on your own thinking. I think that an opinion is not an autobiographical or an egocentric exercise. I think the personality of the judge should be submerged. And I think that framing the issue in the legal terms is a way to do that. It's, again, a discipline on the writer. Much of what we do is a discipline on the writer, I think.
What about a statement of facts in a brief? What are the characteristics of a really good statement of facts?
Well, it's a little hard for me to tell brief writers and lawyers how to argue or write their cases because, in part, and this may sound like it's immediately contradicting what I've just said, the personality of the lawyer and of the advocate have a role. You can't wholly suppress your own personality. I don't think you should. I think you should as a judge. I don't think you should as an advocate. So what might be my style might not be yours. But the most important thing in a brief, when you state the facts, is you must be fair. Now, we know that the plaintiff's brief is going to be slanted for what the plaintiff wants to emphasize, and the defendants too. We expect that. But I think the reader has to have confidence you're being fair. And one way to do this is to say, the appellant, if that's who you're representing, is convinced that the district court erred because it did not give sufficient weight to some of the very important facts in the plaintiff's case, and they are these. Now, that's immediately fair, because you're acknowledging that what you're doing is you're talking about the plaintiff's side. And of course, that should be up in front, and that's very important to get the judge interested in your case. But you can't conclude by allowing a loophole or an opening for your learned friend on the other side to say that you've been selective with the facts. And you say, these facts are so important that in our respectful submission, they wholly overcome what the appellee is going to tell you, which is that, and then you state the appellees and try to take the wind out of his or her sails in that respect.
It's a very important thing to do, isn't it? To take the wind out of the sails of the other side, whatever they're going to say.
Yes, that's a good tactic. And if you're on the other side, then you've got to put the wind back in. That's the fun. And I have to be honest. I've read briefs now for 33 plus years, and I can't remember one I couldn't put down in the middle. I have to tell you that. On the other hand, I do admire well-written briefs.
Last week, I was in London interviewing a British judge who told me that he thought, first and foremost, that for an advocate to be persuasive, the advocate had to be likable. Does that make sense to you?
Well, again, it's style. I suppose there are advocates that distinguish themselves by being mean and egocentric, but they're so good that you secretly admire them. Sort of a Richard III advocate. Was ever woman in this humor wooed? Was ever woman in this humor won? I mean, he's so absolutely outrageous, you kind of enjoy it. I guess you can get away with that. I couldn't do that.
So it's a good idea probably to be likable.
Yes, but there's a difference between being likable and being patronizing. Being fair and being a sycophant. Being balanced and being namby-pamby. There's a difference.
What is the patronizing, let me ask the question again, what is the patronizing advocate like? What are examples of patronizing from the bar?
There's a line between being respectful and deferential and being so patronizing that you're ineffective. Well now, Judge, I'm not the one to decide, but let me say that I think what you ought to do is, that's not good advocacy. That's not good advocacy. In fact, there sometimes if a counsel tries to be the law professor and give me a little of this and a little of that, I miss the advocate. Of course, I'd love to try cases. Frankly, I miss the courtroom. I loved trying cases, and I loved arguing cases. One time, we had a moot court competition, and this counsel wasn't doing very well, I didn't think, the student. And so I asked him a few questions designed to help his case. What do you call them? Softball questions. A question he should have hit out at the park. He was so suspicious of me that he said, oh no, that's not right, and he should have said it's right, it helped his case. So finally I couldn't stand it anymore. And I said, what size suit coat do you wear? And he looked at me with this frown. And he said, 41 long. I said, take it off. And I went off the bench, and I put his coat on, and I put my robe on him, and I put him up on the bench. I said, now here's how you should answer that question. I just couldn't stand it any longer. Now, many judges who've been trial lawyers feel that way. We wish we were down there. And this was a moot court, so I could do it. And I think it helped get the message across about what advocacy should be. I was never invited back to that school.
Have you learned things since becoming a judge that you wish you'd known when you were an advocate?
Oh, yes, and I suppose it's most of the things that I'm telling you about. I've learned that the judges really want your help. Especially in this court, we have very difficult cases. The amount of time we give is so short that it is cruel. My colleague Justice Breyer and I wish we had more than 30 minutes per side. The English judge you mentioned would have been horrified and would be horrified that we would have only 30 minutes. For the English, their language, their diction, their orality, their writing style is their great national resource. And to them it is something close to treason to limit oral argument to 30 minutes. But we have only 30 minutes. We need that help. And I didn't realize before I went on the bench how much the judges really want the help from the advocate. They're not there, it's not pretend. They're not there pretending. They want the advocate's help. And especially and sometimes we're harder on the side which we think is right than the one we think is wrong, because if we think it's right, I might have to write the opinion, and I want help. And we're talking, I guess, more about advocacy style than writing, but I think the same applies to briefs.
Let's talk about oral argument a little bit. What could advocates do to help the court more than they typically do?
We sometimes criticize the arguments before our court. I must say that in the run of cases we have very fine advocates. I think they could realize the dynamic, they could understand the dynamic a little bit better. They could understand that when I'm asking a question, I'm sometimes trying to convince my own colleagues. And so they could answer not just me, but answer based on what they think the whole court needs to know to decide the case. And the other mistake they make is they don't realize, on our court especially, that we've taken the case, because we're a court of discretionary jurisdiction, we have taken the case in order to give guidance in other cases. And so it's not just if they win or if they lose. What's at stake is what the rule ought to be. And the other mistake is the other mistake is lawyers sometimes speak for their clients, and they want to tell, this is especially in courts of appeals, and sometimes trial courts, they want to tell the client what the client wants to hear. I'm not interested in that. Another mistake they make, and it's the same way in writing, is they want to tell us about the easy parts of the case. I'm not interested in the easy parts of the case. The good lawyer is one who says, the proposition that we wish this court to adopt is X. We think that is the correct rule for this case, because justice will be served, and for other cases. We recognize that there are authorities against us on this point. We recognize, in fact, Your Honor, that this is an uphill battle, but we are here to tell you why we think this rule should be adopted. Now, that's an honest statement, and then the judge knows where you're going.
Why should lawyers be willing to answer hypothetical questions?
Because we ask hypothetical questions in order to test the dimensions, the meaning, the significance of the general rule. And a common mistake is for the lawyer to hear the hypothetical and say, well, now that's not this case. Well, I know that's not this case. That's why I asked the question. So you have to accept the argument dynamic that the court sets for you.
Can you think of any adjustments you'd like to make to Supreme Court practice?
Yes, I would like longer time for oral arguments, because I love oral arguments, and I think it's cruelly short.
It is interesting. What explains the reason that American advocates rely almost wholly on the briefs with a very foreshortened oral argument, but the British have almost no briefs, at least just kind of some points relied on, and it's all oral argument? It's
just the opposite. Mm-hmm. And as you indicate, and I've sat on the House of Lords as a visitor, not voting, the cases will go on for 3 and 4 days. Part of the reason is the English judges use the barristers as we use our law clerks. The English judges are learning about the case in part for the first time, and they will actually say, well, let's read this case, and they'll bring the case down on the bench and read it. And this is a wonderful system, but it's inefficient. We could not, with our caseload, have that system. We have to be prepared in advance.